Hey guys, this is Sebastian, president and partner here at Guerra Wealth Advisors, where we help families get to the point where work becomes an option and not an obligation. If you're an individual that's planning on retiring over the next couple of years, or you're looking to optimize your investments, minimize your taxes, and build a solid estate plan, don't forget to subscribe as we put out videos on a weekly basis as it pertains to the subject of retirement and your money. So recently I met with John and Susan. He was 68 years old, his wife was 60 years old, and one of the biggest concerns that they had was who's going to get all of our wealth when we're not here. They had 3 children and they were concerned about what happens if they're married, what happens if they have children. How do we make sure that all of our money, all of our wealth stays in our bloodline? So right now they had a primary residence that was worth about $800,000, and they had 2 investment properties. One of them was worth about $500,000, and then they had another one worth about $700,000 as well. They had an IRA worth about $600,000. They had a brokerage account with about $200,000, and then they had inside bank accounts about $100,000. So when you add up their entire wealth, it was almost about $3 million that they had between all of these accounts. Now, the crazy thing is that if you start looking at everything that they put in, you see that they bought this property for $125,000. They had another property that they purchased for $300,000, and then they had their brokerage account where they only deposited $50,000, and it had already grown to over $200,000. But when you start looking at what's called a beneficiary designation, which is a very, very important element as far as who gets all the money, who gets all of these accounts, who gets all of these assets when they're not here, here's where it got a little bit interesting. Because when you looked at their primary residence, right now the property where they lived at was 100% owned by only the husband. We'll talk about in a minute what the consequences of that might be. The second thing is we looked at the other properties, the 2 investment properties, and those 2 properties were right now owned under an LLC. That means they were owned under a corporation. But now the question is, who owns that corporation? And that corporation was owned exclusively by only the husband. So we'll talk about the consequences with that. They had another retirement account, which was the big $600,000 retirement account, and they only had 1 child as the beneficiary of that account. We'll talk about that as well. And then they had a brokerage account where it had no beneficiary, and then their savings account at their bank, they also had no beneficiary on the money that was sitting at their bank as well. So I think this is one of the biggest challenges that a lot of people go through, is they open up all of these accounts, they open up investments, retirement, they buy properties, but they're not thinking about the consequences for the day that they're not here. Who's eventually going to get all of these assets? So I want to make a quick disclaimer. I don't want you to go and grab the information that we're about to cover and you're going to go and implement everything exactly how we talked about it. Because one of the challenges that we see with a lot of people is that they're going to go and learn information about their estate planning and how to set up a will and a trust, and they'll try to go and implement it, and then they do it completely incorrectly, and this can create a lot of problems for your family. So this is something that you want to make sure that you're meeting with your financial planner as well as your estate planning attorney in drafting all of these legal documents up. So we're going to go over 12 specific things that you, or in this specific case, this family needed to go through to make sure that their family is not fighting over their wealth. So the first thing that we notice is that the property was titled under the husband's name. Now, you might be thinking, well, what's wrong with this? Well, the challenge with that is that if he were to pass away right now, well, who owns the property? Because even though he's married, even though it is his wife will technically not own the property yet. That means his wife will now have to go through a process called probate just to get control of this property. So instead of just leaving the property under the husband's name, we could also do what's called a joint tenant with right of survivorship assignment on the property, which means that if he were to pass away, the property automatically goes to the wife. Or the other option is, instead of just doing that, we can also just make sure that they have what's called a revocable living trust. If he wants to keep control of the property, maybe he bought it 10, 20, or 30 years ago, we can just make sure that that property is under his name, but then if he happens to pass away, the property is already titled in the name of his revocable living trust. And then in that trust, he could also assign his wife as the trustee and as the beneficiary of it. But if he wanted to keep control of the property while he's still alive and him still be 100% the owner, that would be a way of doing it so that his wife doesn't have to go through all of the challenges of probate. So the second issue that we noticed is that they had all these accounts, they had bank accounts and investment accounts that didn't even have beneficiaries assigned to the account. Now what that means is that it also has to go through probate. And now just to go through the process of probate, that now is going to cost the family anywhere between 3 to 5% of all of the assets is going to be the cost potential for the beneficiaries of that money. So imagine if it's a couple $100,000 or a couple $1 million and there's no beneficiary assigned. Imagine 3 to 5% of that amount. So imagine just 5% of $1 million. That's $50,000 in just probate costs, just simply because those assets were not assigned to a beneficiary, or those accounts did not have a trust as a beneficiary. So if you want to keep control of those assets after you pass away, you might want to create what's called a revocable living trust, so that all of the assets go into that trust, and then the rules of that trust are followed after you're not here. If you don't care about the way the assets are managed after you're not here, then maybe you just want to assign a beneficiary so that that account just goes straight to that person, but it still doesn't have to go through probate. So the third issue that we notice is that they had all of these properties under an LLC. Now, you might be asking, well, Sebastian, what's wrong with having investment properties under a limited liability corporation? Isn't that a good thing? Doesn't that protect us against liability? Well, yes, it can protect you against potential liability, but the problem was that this LLC was only owned by the husband. Now, I don't think he intentionally did this, but he bought this property under an LLC, and he is the 100% owner of that LLC. So if he happens to pass away, well, now who owns the LLC? That means that the LLC in itself will also have to go through the process of probate. So we're going through the whole issue again simply because there's not a beneficiary assigned to that LLC. So the way you can solve it is by grabbing your revocable living trust and making sure that that owns the LLC. So that if you happen to pass away, now the LLC is already owned in the trust. Even if you're not here, your trustee will still control the trust, which essentially will control the LLC, which essentially will control those two properties. So the fourth issue that we notice is that the retirement account, the IRA, had one beneficiary assigned to it, and it was only one of the three children. Now, I asked him, why did he only have one child? And he said, because he trusted his son more than the other two as it pertains to the subject of money. But you might be asking, well, what's the problem with this? Well, the first problem is that now all of the money is going to eventually go to the son, and it's not going to go to his wife. So that's a question you might want to ask yourself. Do you want to make sure that your money goes to your spouse? Normally, this is something that you do want to make sure that happens, because you don't want to have your wife or your spouse be struggling financially because now all the money ended up going to maybe your son, and then now your wife has to go ask your son for some of that money back. The other problem with this is that now that IRA, since it's assigned to the son, any money that comes out of it, he will be the one 100% responsible for having to pay the tax. So imagine there's an $800,000 retirement account that was now assigned to your son because he is the 100% beneficiary, but you wanted that money to go to your three kids. Well, the one stuck with the bill for when it comes to the IRS is only that one son. So instead of doing that, you might want to consider that the funds get distributed straight to your spouse if you want to make sure your spouse is the one in control, or those funds can go into what's called a retirement trust account. That way we can make sure that those funds, instead of just going to your children and they can blow the money however they want, the money can go into the trust account with specific rules and conditions on the way you want those assets to be distributed. So the fifth issue that we notice is challenges that can happen after they're not here as it pertains to family fighting over money. This is the reason why you want to make sure that all of the assets get distributed over to your trust, and you have all of the rules and all of the conditions on the way you want your money to be distributed. And don't just go and put your beneficiaries on there and then all of a sudden now your children end up finding out later. This is exactly how challenges happen with families, because one child got $400,000 and the other child got $700,000, and now they don't know the reason why. So this is why it's very important that you have a family session, a family meeting where you go over all of these things in your trust and you've explained to them why you're going to be doing all of these things. Now, every family is very different. Some families don't even care. They're just like, hey, I'm going to let my kids fight over it. Some parents want to make sure that their family and their children know these things before they actually happen. So the sixth issue that we notice is that if you have an IRA, which in their case, they had an IRA with a significant amount of money, is that there's a massive tax impact for the children when they go and inherit the money. And there's a rule that says that after you pass away, there's a 10-year window where your child, your heirs, have to exhaust the entire retirement account within 10 years of the last spouse passing away. So for example, if you pass away, leave everything to your spouse, and then your spouse passes away, leaves everything to your children, then your child has a 10-year window to exhaust the entire retirement account. That means they don't really have to pay any taxes yet, but as the IRA keeps growing and growing and growing, once they hit the 10th year, on year number 10, they have to pull the whole thing out of the account, and whatever the balance is, your child is going to have to pay the tax on the entire balance. So instead of doing that, what you might want to consider is start converting your money, your IRA, into, for example, a Roth IRA, because once the money's inside the Roth IRA and after you pass, your child can now inherit the Roth IRA, let it keep growing and growing and growing for up to the 10 years, and they don't have to pay a dime in tax on any of the growth during that 10-year window, And at the end of the 10 years, they can pull the whole thing out and it's 100% tax-free. So if you're an individual that is really prioritizing the subject of estate planning and you want to make sure your will is set up, your trust is set up, your powers of attorneys are drafted up, feel free to reach out by clicking on the link below. You can book a session with one of our wealth advisors. You'll meet with our wealth advisory team as well as our estate planning team to make sure that your entire legal structure is set up the right way so that your funds get transferred over to the next generation and your heirs with the least amount of problems possible. So the seventh issue that we noticed is that they were planning on selling their investments that had appreciated in value. Now, you might be thinking, well, what are the problems with selling investments that have gone up in value? Well, in their case, they had significant amount of money sitting inside a brokerage account that had appreciated in value significantly. And what a lot of people don't know is that let's say that you bought Apple stock and you spent $100,000 on buying Apple stock. It went up to $1 million and now you wanted to sell the Apple stock. Well, there's normally something called a capital gain. And that capital gain can be anywhere from 15 to 20 to 23.8% if you add something else called the net investment income tax. But that could be a significant amount of taxes that could be paid if you happen to sell the Apple stock. But a strategy that you could implement if you're looking to maximize your estate, your legacy that you leave behind, is you can use what's called a step up in basis. What that means is that if you bought the Apple stock for $100,000 and it's worth now $1 million, if you hold on to the stock until you pass away, your child can inherit that entire stock, sell it, and they don't have to pay any taxes on the entire appreciated value of the stock from the moment you bought that stock 5, 10, 20 years earlier. So if you're looking to maximize your legacy and you have investments that have appreciated in value, like stocks, like real estate, you might want to hold on to those assets until you pass away. So that way you can maximize the legacy you're going to leave your family and they don't have to pay taxes the moment you pass away and they sell that property. So issue number 8 that we notice is something called estate tax concerns. Now, a lot of people don't know really what estate taxes are, but pretty much the way the US operates is that there's this rule that says that if you happen to die with over $13.9 million as an individual, and if you're married, it's about double the amount, then the government charges something called an estate tax, which is about 40% of anything that you leave behind. So imagine if I'm filthy rich, I got 20, 30, 40, 50 million dollars, and I have, call it the estate tax exemption is 13.9 million, call it $14 million, then everything above that amount, I have to pay, or my family has to pay, my heirs have to pay a 40% tax on everything that I leave behind above that $14 million number. Now, the crazy thing is that the government has the law and has the power to bring that number down. That means that if right now it's sitting at $14 million and 10 years into the future, the government decides that they're going to tax every heir, every inheritance that is left behind on anything above $1 million. Now, imagine in their specific case, they have a couple $1 million. So that means that if tomorrow they pass away with $5 or $10 million between real estate and investment accounts and all of this stuff, and now the estate tax exemption is only $1 million and they pass away with $5 million, then there's a $4 million estate tax issue that they're going to have to deal with. And 40% of $4 million is about $1.6 million in taxes that are going to have to be paid. So one of the strategies that they can implement is you can do a strategy called gifting, which means that they can now start gifting money away to people that they know are going to inherit their money, maybe their children. They can start giving that money away right now. So they can start giving away up to $14,000, $15,000 a year, and all of this money that they're giving away to their children, obviously they lose control of the money, but the beautiful thing is that it's not part of their estate. So if tomorrow the government decides to bring that number down, that estate tax limit from $14 million down to $1 million, and then they pass away after that happens, they've already now gifted a bunch of money to their children. So now the children don't have to go and pay that massive tax because they were already gifting this money away. And normally this gifting strategy is something that you want to implement for every child, especially if you like your child, or every grandchild, especially if you like your grandchild, so that you can make sure that your assets get transferred to the next generation and they can avoid potentially that estate tax. So the other question is, what happens if they're incapacitated or something happens where they're involved in an accident and they now cannot be making financial decisions on their own anymore? Well, who's now the financial decision maker? So that's why it's very important to create what's called a durable power of attorney, or also a financial power of attorney, because this can assist in now you're assigning someone to make financial decisions for you when you cannot make financial decisions for yourself anymore. And this is all part of what's called an estate plan. The 10th issue that we notice is that there was no medical directive. Now, this is very different than a financial power of attorney. A medical directive now says, okay, who are you now going to assign to make medical decisions for you when you cannot make medical decisions for yourself? Is it going to be your spouse? Is it going to be your children? Some people end up saying, I don't trust my spouse as much. I'd rather trust my child more in making decisions as it pertains to my health. But maybe as it pertains to subjects on money, maybe you might trust your spouse more. So it's very important that as you're building your estate plan, you're not just thinking about who gets your money after you pass away, but you're also thinking about what happens the day that you can't make decisions on your own. Whether financial decisions or healthcare decisions, you want to make sure that these documents are drafted up so you've already appointed these individuals before those events happen. So issue number 11 that we notice is what happens if the children now inherit all this money, they get millions and millions of dollars, and now they're involved in a lawsuit. Well, what can happen in that moment? Well, if there's a lawsuit and they have all this money assigned to their name or they have a bunch of creditors after them, now all of the inheritance that you now left to your children could potentially be wiped away just simply because they made a mistake. They were involved in a lawsuit. So if you want to protect your children from potentially going through a lawsuit like this and losing all of the wealth that you left behind, you might want to consider something called an asset protection trust, because this can also practically guarantee that all of the assets that end up going to your children, if a lawsuit were to happen to them, then the assets that you left to your children, no one can go after those assets in the case of a lawsuit. And issue number 12 that we notice is that the properties were also not protected against creditors as well. So one of the strategies that we recommended and our estate planning team recommended is that we wanted to make sure that that property not only was under an LLC, but was also titled and owned by the trust. So this could also protect that if a creditor were to want to go after them, the assets can be protected in the case of a lawsuit. So instead of just having the properties under your personal name, where there's a lot more exposure in the case of a lawsuit, by putting it under an LLC and that LLC being owned by the trust, this could potentially protect the assets against most creditors. So don't forget to grab this video and share it with a loved one. I can't tell you how many people wish that they would have learned this information before these events happened. There's so many challenges that pertains to estate planning, setting up your wills and your trusts and your powers of attorneys, that all of these documents, it is critical that we set this up before these events happen. So don't forget to share this video with a loved one. See you on the next video.